Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. Today on this video, we're going to be dealing with estates. Before we get started, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our topic. In this video, estates will be dealt with in relation to estate planning, wills, and administration of estates. It is important to plan out your estate because in planning out your estate, you state who is to derive benefit from your property. This estate planning can be done through the nomination or appointment of beneficiaries when a person has a policy or a pension. It, however, has to be borne in mind that the company where the pension is taken from can redistribute the benefit according to what they think is fair. For example, when a person takes out a policy at a time when they only have one child, and at the time of their passing, they have 2 or 3 children, and they forgot to change the beneficiary on their policies to include the other 2 children, then the company that is supposed to give out the money can assess and decide to split the benefit between the 3 children. It also has to be borne in mind that you should remember to update your policies and pension documents from time to time. In relation to wills, a will is a written document where a person called a testator sets out who is to get a benefit from their property. This document, in order to be said to be a will, has to comply with the requirements of the Wills Act. In terms of the Wills Act, there is a certain way that a person has to sign a will for it to be valid, and it further states that a person who is a witness to a will cannot benefit from the said will. Please engage the services of an attorney to ensure that your will properly complies with the law. Otherwise, the will might be said to be invalid, meaning that your wishes cannot be fulfilled. A will is important because a person can state who a beneficiary is, and this beneficiary might not be a person who has the automatic right to inherit from the testator. An example of this is children born out of wedlock to men. In my video dealing with marriages, I set out that such children do not have the automatic right to inherit from their fathers. They only have a duty of support. Therefore, if a man wants their child who is born out of wedlock to inherit from their estate, then they have to say so in their will. A person can also leave a benefit in favor of a lifetime partner who they never married, or they can also protect their children or spouses who have an automatic right to inherit. An example of this is, in my previous video dealing with marriages, I explained how inheritance is to be divided between people where a person has left no will. Example is, if there is only one house where this person and their spouse was living, and these people had 2 children. If one of the spouses passes away without a will, then it means the house has to be split between the spouse and the children, and the manner of the split you will have to determine based on what the applicable law is. The children might ask the surviving spouse to sell the property or pay them out. And if the surviving spouse is elderly and they are not working, then they might not be able to pay the children out for part of the inheritance. Meaning that the children can force the surviving spouse to sell the matrimonial home. And if the spouses had no other home aside from the matrimonial home, then the surviving spouse would be left with nowhere to live. This is also true in respect of protecting children. A person can ensure that the children are protected in that they are stopping the surviving spouse, especially when children are young, from dealing with the property as they like. An example is where one of the spouses passes away without a will. The children are minor, maybe 2 or 3 years old. The surviving spouse might remarry in community of property. And if they are allowed to deal with the property from their previous marriage as they like, then there's a possibility that they might disinherit the minor children. So a will ensures that these minor children's rights are protected. A person also has the right in terms of a will to leave their property to whomever they like. They can leave it to a charitable organization. They can meet a person on the street and leave them their property. There are, however, certain exceptions that have to be considered when a person creates a will. One of the exceptions is that a child who is below the age of 18, considered to be a minor child, has the right to be supported by their parent. So if a will leaves something completely to a charitable organization and nothing to a minor child, then the court can step in to make provision for support for the minor child from the estate of the person who has passed away. Certain other issues to consider in respect of wills is the issue of a joint will. A joint will is usually made by people that are married. And it is pertinent to consider where, in creating a joint will, the spouses say, whomever of us passes away first, the property will go to the one who survives. And the one who survives, upon passing away, the property will go to the children. If one of the spouses passes away after the creation of this joint will, then the spouse that remains cannot change the joint will. The reason why they cannot change the joint will is because in that joint will, they agreed that they're leaving the property to the children upon the last of them passing. And because the other one has already passed, there is no one else to sign another joint will with the surviving spouse. And in that respect, the surviving spouse will be bound to the terms of that joint will. There are, however, exceptions. And the exception to this is if in a joint will, the people specify the property to be dealt with. Example, if they have 2 houses and they say the first of one of us passing away, both houses will go to the surviving spouse, and upon the passing of the surviving spouse, both houses will go to the children. If during their lifetime, the surviving spouse acquires more property, then that surviving spouse can create a separate will where they deal with the other property. However, they cannot deal with the 2 houses because they are subject to the joint will. Now, the next issue to look at is administration of estates. Administration of estates comes into play where a person has passed away and it is necessary to gather all their property, all their assets, liabilities, in order to distribute them to the people that are to benefit after paying off any liabilities. In dealing with administration of estates, there are various things to look at. The first thing is whether or not this person has a will. The second thing is whether or not this person is married. If they are married, whether they signed a Form A or B that includes or excludes customary law. And the third thing is, if this person is not married, are they a tribesman? I will go through all of these in this video to explain the different issues related. If a person passes away and they have a will, then the property will be dealt with according to that will. It makes no difference whether or not this person is a tribesman, as long as they have a will. Secondly, the will has to be valid. And when I say valid, a will cannot deal with things that do not belong to the person who creates it. An example, if people are married in community of property, it means they each have a 50% share in the joint estate. A person who is married in such a regime cannot make a will dealing with 100% of the joint estate. If they have a house, then the person can only deal with their half share in the house. They cannot decide to leave the entire house to someone else, especially because this house, only 50% belongs to them, the other 50% belongs to the surviving spouse. In dealing with wills and administration of estates, what people do is they have to report the estate to the master using the prescribed form and attaching the necessary documents. And the necessary documents include the death certificate of the person who has passed away and a copy of the original will. Once the estate has been registered by the master will issue out letters of administration. These letters of administration will have the name of the person appointed in the will as the executor of the estate. And it is important to talk to people before you appoint them as executors in your will so that they are aware. There are various instances where you find people appointing others as executors in their estate. Once the person passes away, you reach out and say, oh, by the way, this person has appointed you as an executor, and the person is absolutely shocked. Therefore, you need to talk to a person before you make them the executor of your estate. And that is because the office of executor is important to ensure that the administration of estate is done properly. After the executor is given the letters of administration, then the executor has to gather all the property belonging to the deceased. They then advertise for what is called debtors and creditors, and they give 30 days from the date of advert to receive a response to the said advert. After the 30 days, the executor will prepare what is called an updated inventory. And the reason why it is updated is because an inventory is one of the documents submitted when reporting the estate. The updated inventory would have a list of all the property that the person who passed away had. It will have a list of all the people that are owed or entities owed by the person who passed away, if there are any liabilities. And it will also say who owes or owed this person during their lifetime or at the time of their passing. This updated inventory will then be sent to the master. If there are any people that the estate owes, authorization will be asked for from the master to be able to pay these people. If there are people that owe the estate, then the executor or their duly appointed attorney will reach out to the debtors to ask them to pay the money into an estate account. Once everything has been dealt with, then the executor prepares what is called a first and final liquidation and distribution account. In that first and final liquidation and distribution account, again, they repeat all the property, all the liabilities, and all the people that owed the person who passed away at the time of their passing. In addition to that, they will also set out the people that are to inherit, and against them it will indicate what properties they have been allocated in terms of the will. There, however, has to be a thing that needs to be looked at, and the thing that needs to be looked at is what impact the liabilities in the estate had to the distribution. For example, if a person had a car worth 50,000 pula, but they had people that they owe worth 10,000 pula, then the estate shares can only be divided according to the 40,000 pula that is left over. And if the heirs or beneficiaries are not able to pay that 10,000 from their pocket, then the car would have to be sold, the 10,000 pula paid, and then they have to share the 40,000 equally, especially if the will does not leave the car to one person. If the will leaves the car to one person, then that one person is the one that should take the 40,000. After the first and final liquidation and distribution account is prepared, it is then taken to the master for authorization. The master will look at it and see if it is in line with what is in the will. And if the master is happy with it, then she will authorize for this first and final liquidation and distribution account to be advertised. In the advert, what comes out is merely to say the first and final liquidation and distribution account in a certain person's estate is open for inspection, and it will be open for inspection for 30 days. You do not actually publish the actual first and final liquidation and distribution account. During those 30 days, a person can come and challenge the distribution. And a person can challenge this distribution on various grounds. For example, they can challenge it on the basis that the distribution is not done in terms of the will. If there's a challenge, the challenge is dealt with by the master. The master can either uphold that challenge and redistribution is done, or the master can dismiss the challenge. Once the challenge has been dealt with, the executor or the appointed attorney then asks for the master to authorize distribution in terms of the first and final liquidation and distribution account. This authorization only comes at the end of the 30 days set out in the advert. Copies of this advert have to also be furnished to the master. If the master authorizes distribution, then the estate property is distributed in line with the first and final liquidation and distribution account. Proof of distribution is then given to the master, and the executor returns the original letters of administration and asks to be released. If the master is happy that distribution has taken place in terms of the will, then the master will duly release the executor. This situation is where there is a will. If there is no will and the parties are married, but there is no Form A or B, or the Form A or B that they have signed does not exclude customary law, then the question is, are they a tribesman? If they are not a tribesman, then the process to be looked at is similar to the one just set out. However, there are two main differences. The first difference is that the master will, in this instance, call a meeting. And at that meeting is where the executor will be appointed. The people to attend this meeting are usually the family of the person who has passed away. The other main issue that is different is that the distribution will be in terms of the succession, rights of surviving spouse, and family inheritance provisions. And I deal with this distribution in my video on marriages, so look at that to get a full appreciation of how this distribution happens. This is in the instance of where there is no will and the property is dealt with not according to customary law, but according to common law, because the people are not tribesmen. It should also be looked at where people are not tribesmen. The distribution might be different if they are domiciled in another country. The distribution will be done in terms of the laws of the country where they are domiciled, which country is not Botswana. However, if customary law applies because these people are tribesmen, in administering an estate under customary law, the family has to meet and agree on an administrator for the estate. And this agreement, especially in dealing with immovable property, has to be in writing, and it has to be signed by all family members present at this agreement and have written against their names their ID numbers and should be accompanied by copies of their ID. This resolution is in the form of a letter which has to be stamped by the Khosi of the area where the family is and where the person was living. The Khosi also writes a letter to explain that these people are known to them and the person who passed away is known to them, that the resolution was duly signed by the family. In that resolution as well, the family will set out the people that are due to inherit from the estate. If it is quiet about who gets what, then it is usually distributed 50-50. Example, if there was immovable property in the estate, there was a surviving spouse and one child, then they will each get 50% share in the property. However, in that same resolution, they can allocate specific property to a specific heir. This is done bearing in mind that the distribution is done in terms of customary law. So, after all of these documents are gathered, then the person who is appointed as the administrator moves around with these documents or copies of these documents to facilitate distribution. Unlike in the common law situation, there is no one who will issue letters of administration to this administrator and the administrator will not require to be released. However, the administrator must ensure that the property is divided as what is written in the family resolution. That is the end of our topic on estates. If you have any questions or queries, please comment down below. And please like, share, subscribe. Follow me on my social media, being on Facebook and Twitter. You can find links of where you can find me additionally also in my description. And thank you for joining me. I hope you got useful information from this video and that you will be wiser for it. However, please always get the services of an attorney if you have legal problems. If people tend to do things themselves, usually when disputes or problems arise, it is more difficult for attorneys to fix these problems than if the attorney started off the estate from the beginning. Thank you very much for joining me on my channel. Bye!